Hi, welcome to the Week 6 bonus materials for Professor Akil Amar's Constitutional Law class on Coursera. I'm Daniel, one of your teaching assistants, and along with me here is Danny, another one of the teaching assistants. And today we're going to talk a little about what constitutional law looks like in the modern world today. And we're going to do that by discussing a couple of important court cases that involve constitutional law that are being decided this year in the United States Supreme Court. So just to lead things off, I thought I'd talk a little about what the Supreme Court is and how it functions in the American legal system. So the Supreme Court is the highest court in the United States. And while it hears in some cases it's a court of original jurisdiction where it hears cases for the first time. In almost every case it hears, it's a court of appeals. So it's going to be hearing cases that have already been decided in other courts and determining whether those courts made the right decision or the wrong decision. And now the way you get into the Supreme Court is by a complicated process called certiorari. So after you've lost a case in a lower court, you can petition the Supreme Court and say, hey, I think that the lower court got it wrong. I want you to review this case. And thousands of people every year do this. And the Supreme Court only agrees to hear about 70 of those cases. And they're the cases that present the most interesting, the most compelling issues, have caused the most disagreement in lower courts. But with those 70 cases, then, it will have each party. In the Supreme Court, the parties are called the petitioner, who's the person challenging the lower court ruling, and the respondent, who's the person responding and who won below. Each of them will submit briefs, so that's written summaries of what their arguments are. And then each of them will get a chance to present oral arguments before the justices in which they can make their case. After the justices hear oral arguments, they will discuss with each other what they're going to do and eventually come to a ruling, and the majority will get to write an opinion saying what the court is doing and why they're doing it. Other justices who disagree can write either concurrences, in which they say, I agree with the result you came to, but I want to give slightly different reasoning for it, or dissents, in which they say, I don't agree with the result. Here's what I think should have happened instead. So that process goes on. The Supreme Court calendar runs from October through June, basically, and hearing cases and then deciding them as they go. And so we're going to talk about a few of them today.
Thanks, Daniel. So one of the things that's important to realize is that in this Supreme Court process, not everything that the Supreme Court does is constitutional law. There are plenty of cases that are about things other than the Constitution. For instance, statutes that are laws passed by Congress or regulations that are passed by federal agencies. And the Supreme Court will determine what the authoritative interpretation of a statute is, or it will determine whether an agency's action or regulation is in line with the statutory authority granted by Congress. But in keeping with this course, we decided to take a few cases from this term that are about specific parts of the Constitution, specific texts within the Constitution, and about how those texts have been interpreted by the Supreme Court and other courts over time. So today we're going to talk about three cases. First, the National Labor Relations Board versus Noel Canning, which is a case that deals with Article 2, Section 2 of the Constitution. And then we'll talk about United States versus Worry, which deals with the Fourth Amendment. And finally, Town of Greece versus Galloway, which is about the First Amendment.
So the first case that we're talking about today is National Labor Relations Board, or NLRB for short, versus Noel Canning. So as Danny said, this case arises under Article 2, Section 2. And now, if you remember from chapters 4 and 5 of Professor Amar's book and the lectures that correspond to them, Article 2 is about the president and the powers that the president has. Now, one of the most important powers that the president has is the power of appointment. So this is what the Constitution has to say about presidential appointments. This is in Article 2, Section 2. He, that's the president, they weren't really thinking of female presidents at the time, I guess, shall have power, by and with the advice and consent of the Senate, to make treaties. So that part of the clause is not relevant here. But then also to appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States whose appointments are not herein otherwise provided for and which shall be established by law. And then it says in the next clause, so that's setting up the primary mechanism for appointment, which says the president's going to make a nomination, but then the Senate has to provide advice and consent. It has to agree to the nomination the president's giving. But then there's a catch, which is that in the next paragraph it says, the president shall have power to fill up all vacancies that may happen during the recess of the Senate by granting commissions which shall expire at the end of their next session. So this is called the recess appointment clause, and it establishes the recess appointment power. You may have heard about recess appointments, but basically they're appointments that the president makes when the Senate is in a recess, when it's not meeting, and they last for just a year until the beginning of the next Senate session. So they're temporary appointments that don't require the consent of the Senate. So the case of Noel Canning v. NLRB concerns how far that recess appointment power goes. Specifically, it relates to a few appointments that President Obama made to the National Labor Relations Board. And he made them as recess appointments. And this was back in January of 2012. And he said, well, Congress isn't in session. I want to appoint these people to the National Labor Relations Board, so I'm just going to do it. And I don't need the advice and consent of the Senate. But after he did that, some people said, wait a second, we don't think this was a real recess. We think, they made actually a whole variety of claims, one of which was this wasn't a real recess, but another of which was, and this is the one that we're actually going to talk about today. So if you remember, the text that I read to you said, the president shall have the power to fill up all vacancies that may happen during the recess of the Senate. So one question that arises is, does that mean that he has to make the appointment, just mean that he has to make the appointment during a recess of the Senate? Or does it mean that the vacancy that he's filling actually has to arise during that same recess too? And that's one of the questions that's being litigated in Noel Canning. And so what we're going to do here is Danny is going to lay out the position of one side, and then I'm going to respond and lay out the position of the other, so you get a sense about what both of the arguments are. So Danny will start by telling us what the petitioner, and that's the government in this case, says about the recess appointments clause.
Right. So the petitioner in this case is the National Labor Relations Board. That's because they lost in the lower court, which in this case was the appeals court in D.C., the D.C. Circuit. So the National Labor Relations Board cares about this very much because it's currently headed up by people who were appointed via this method in January of 2012, as Daniel said. And so the question is whether the actions that these people have taken while in office are valid actions. And that's really the underlying cause of complaint in the case today that we're discussing today. It was actually argued back in January, although we're still waiting to hear from the court what the decision will be. So there's a variety of arguments that are on the table that the government is making, a lot of which you might recognize in sort of style or pattern from the discussions that we've been having in class so far and in Professor Marr's lectures. Some of these arguments are sort of textual arguments about what the word happen means. And to look at the text, the government's briefs are looking at how the word happen was construed and how the word recess was construed back in the 1780s, in the 1790s, around the time of the writing and ratification of the Constitution. So some of the sources that the government has used are records from British Parliament or records from state legislatures and how they used the terms recess or how they handled recess appointments, the Continental Congress, or even how the Constitutional Convention handled its parliamentary procedure. Another set of arguments is related to the purpose of the clause, what the recess appointment clause was designed to do. And if you look at historical evidence from the time, you see people talking about the recess appointment clause as designed to make sure that the government was still functioning while the Senate was in recess. And nowadays, the recesses between sessions of the Senate are not particularly long. They may be a month, they may be a few weeks, they may be a couple months. But back in the 1790s, during the first Congresses, often recesses were 6 months long. And the recess appointments clause was seen as a fundamental way to keep the government functioning, to keep executive offices filled when the Senate was not in session to confirm them. So one of the arguments the government makes is that with this purpose in mind, think again about what it means to have a rule that the vacancies that are being filled by the president had to exist during the recess, or they could have arisen before the recess commenced. And think about, for instance, a vacancy that's created because, let's say, a military officer dies 2 days before the Senate goes into recess, and word doesn't make it to the Senate, or the Senate doesn't have the time to confirm a new appointment by the president before it goes into recess. Now, that would be a vacancy that arose before the recess happened. But it seems like if the purpose of the clause is to allow the government to keep allow the president to keep the government functioning during the recess, you would certainly think that having important military positions filled would be a necessary thing for the president to be able to do. So that's sort of an argument based on the purpose of the clause. Then there are arguments about the history of how this clause has been interpreted. So one thing you might think when you read this clause again, that the president shall have power to fill up all vacancies that may happen during the recess of the Senate, you might think, well, it's not clear what the word happen means. Does the word happen mean arise? Does the word happen mean exist? So how should we handle moments when the constitutional text is unclear? And one of the things that the Obama administration is arguing is that we should look to historical practice to see if this is subverting an understanding that has existed for centuries. And they say, no, it's not. It's unsurprising that they say that, of course. They say nearly all presidents have made appointments to pre-existing vacancies, to vacancies that arose while the Senate was in session, but the appointment was made when the Senate was in recess. They also point to letters from the Attorney General to the President interpreting the President's authority to do this, dating back all the way to 1823. And they note how many officers have been appointed this way. It's hundreds and hundreds of officers over history, both civilian officers and military officers. And so they say, all right, even if this is maybe an ambiguous text, we should see that this has been worked into the fabric of our Constitution over the last couple centuries. This is a kind of argument that we'll see a lot as we transition into the next half of the course with Professor Amar as he discusses America's unwritten Constitution. You'll get several lectures dealing with what Professor Amar calls America's institutional Constitution, and that's the interpretations of our Constitution, the gloss that's been added onto the text by centuries of executive practice.
Thanks. So Noel Canning, on the other hand, and that's the respondent in this case, says, look, I know we've been doing things this way for a long time. I know for 150 years, presidents have been appointing officials to vacancies that only came about before the recess. But it doesn't matter because the text of the Constitution is clear. Now, as I said before, what the text of Article 2, Section 2, Clause 3 actually says is that the president has the power to fill vacancies that happen during the recess. Now, the most natural meaning of the word happen, whether today or in fact back when the Constitution was originally written in 1787, is that it refers to a sudden occurrence rather than a state of being. If you talk about something happening in everyday speech, you're not really talking about something that's been around for months. You're talking, if you say, I went back home and my mother happened to be there, right? You're not talking about your mother having been there for 6 months. You're saying my mother was there at the moment that I got there. And the most natural way to read as a result, vacancies that shall happen during the recess is that we're talking about vacancies that come to exist when we're in the recess and not vacancies that came about, months or even years beforehand. And related to this textual argument is another purpose argument. So Danny gave you one purpose argument, which was, the Recess Appointments Clause is about making sure that the government can continue to function. So it's important to give the president broad powers to make recess appointments. But another response is, the Recess Appointments Clause is really supposed to be a special exception for times when the normal appointments process, with the president nominating and the Senate confirming, can't work. And if we give the president the power to make recess appointments for for vacancies that have existed for months, then he's really never going to go to the Senate at all, right? If the president knows, this vacancy came about in the middle of the Senate's term, but if I just wait a few months until the Senate is out of Washington, I can appoint whoever I want to that seat without needing the Senate's consent, then why is he ever going to use the normal Appointments Clause process of advice and consent? And so in a way, interpreting the Recess Appointments Clause broadly might actually undermine the purpose not just of that clause, but of the whole appointment scheme that the Constitution was setting up. And then finally, with regard to some of these history arguments, the respondents say, it's not really all that clear. Yeah, it's true that presidents for a long time have been appointing officials whose vacancies came about before recess began. But at the very beginning of our country's history, it was unclear that that was the accepted practice. George Washington, for example, seemed to think that it was really important that you could only use the Recess Appointments Clause to fill vacancies that actually arose during a recess. And so it's unclear whether a historical practice that only started several decades after the founding should really carry as much weight as one that's been continuous since the beginning of our history. So those are some of the arguments that both sides are laying out. And if you're curious to learn more, there's tons of material, on the internet that you can read about this case. And you can look at the briefs and you can read the transcripts of the argument. But now we can move on to some other stuff.
Great. So the next case we wanted to talk about is United States versus Worry. And this is a case about the Fourth Amendment. So just as a refresher, I'll read the text of the Fourth Amendment. And the Fourth Amendment says, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized." So the Fourth Amendment is an incredibly important part of the Constitution for law enforcement. And the question before the court in United States versus Worry is whether when a person is being arrested, can the police search that person's cell phone if they don't have a warrant to search the cell phone? And can they look at data that they may gather from the cell phone? So in this particular case, the defendant was observed during what police officers believed to be a drug sale. And they arrested the man and they searched his phone, which led to more information for them to prosecute him. United States versus Worry is also being argued the same day as another case, United States versus Riley, in which the defendant there was driving with expired plates, and he was pulled over for that crime of driving with expired plates, and the police searched his phone. In one of these cases, the phone that was searched was a flip phone, a cell phone that's just got a flip, and they looked at the call records. In another case, in the other one of the cases, it was a smartphone, and smartphones, as many of us know, have huge amounts of data on them. So the question is, this text in the Fourth Amendment, the persons, houses, papers, and effects, does that apply to a cell phone? And it's a tricky question, right? Because cell phones didn't exist at the time the Constitution was written. And so this is an important case for the Supreme Court to be considering this term.
So the government, in the Worry case at least, is the petitioner. They lost in the court below. The appeals court said that this was an unreasonable search of his phone under the Fourth Amendment. But here in the Supreme Court, they're arguing that that shouldn't have been the case. And what this really turns on is, as Danny read in the text of the Fourth Amendment, it doesn't say that the government can't engage in any searches without a warrant. It says the government can't engage in unreasonable searches without a warrant. So the question is, what's an unreasonable search? What's a reasonable search? And the way that the court tends to figure that out, because the text doesn't really say, right? It doesn't really say, and these are examples of searches that the government can do without a warrant. These are examples of searches the government can't do without a warrant. So the way that the court kind of fills in the details is by looking at precedent, by looking at past court opinions on this subject. This is something that we'll discuss a lot more, actually, when we move to the second half of the course, which we're just getting to now in Professor Amar's second book, America's Unwritten Constitution. But anyway, so when you look at the precedents on searches incident to an arrest, so what can I do when if the police arrest someone? What are they allowed to look at, even if they don't have a warrant? A lot of the court's holdings say, well, what you can do is you can look at anything that's on the arrested person's body. You can, which sort of makes sense. You can search. You make sure they don't have any weapons. You can see what kind of personal effects they have on them when you're arresting them. So the government argues that really should apply to people's phones too. The cell phone is something that you're carrying when you're arrested. And so if our doctrine, if our cases say you're allowed to search what's on a person's body when they're arrested, then that's got to involve their cell phone too. Especially because, in the modern world, cell phones are particularly likely to contain evidence of criminality. Indeed, that's why this case is in court, because the police were able to discover valuable evidence about Worry's drug dealing when they searched his phone. And as a result, the the government claims this is, in line with our doctrine, a totally reasonable search. And that it's no more intrusive, really, than other searches the police might do for stuff that you're carrying. For example, suppose you had a diary in your pocket. If the police can look at your diary, why is that more intrusive than the police looking through your phone? And so what the government basically says is, like, if you want to put some limits on this, you could monitor the scope of how much we can look at on your phone. But it really doesn't make sense to say we have a categorical rule that says no phones. That's not consistent with all of the cases that say it's okay to search what's on your body when we arrest you.
And then, of course, there's the arguments made by Worry in his defense. And it's important to note that the respondent's brief, Worry's brief in this case, has actually not yet been filed. The arguments aren't happening until late April of this year, and so the case is still underway. But you can think about the kinds of arguments that would likely be made based on the arguments that have been made below, or the arguments that have been made in certain similar cases, which are that, yes, as Daniel said, there are all sorts of reasonable things for police to search and take when they're making an arrest. A pat down to see if you have a gun or a knife on you is certainly a reasonable thing for a police officer to be doing in the course of duty. But phones are sort of different, and as Daniel noted, this isn't something that we can get just from the text of the Fourth Amendment. In part, we have to look to doctrines that the Supreme Court has developed over time as technology has changed and as policing has changed. And one of the things about especially a smartphone is that it's a little bit, there are elements of it that are like a diary, but there are also elements of it that are like, your entire computer, all of your business transactions, access to your email, and then also, for instance, if the police hold on to the phone for a while they're questioning you, they can see incoming calls and who's trying to talk to you and hear the voicemails that they might be leaving for you. And all of these things are maybe similar to phone calls, which the Supreme Court has put restrictions on the police's ability to listen in on, or they may be similar to the papers and business effects that the Fourth Amendment seems to be concerned with. And so, there really is, it's interesting because Fourth Amendment doctrine can sort of push and pull on both of these areas. And as we'll see in the next few weeks, Professor Amar will go over, in particular, the rulings of the Warren Court, which many things to say about, some good and some bad. And Worry looks like it'll just be the latest in a long run of complicated Fourth Amendment jurisprudence.
So the last case that we wanted to discuss today is called Town of Greece v. Galloway. And this case arises under the First Amendment of the United States Constitution, which might be the most famous of them all. And what it says is, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press or of the right of the people peaceably to assemble and to petition the government for redress of their grievances. So the First Amendment, as you can tell, contains a lot of really important stuff. Freedom of speech, freedom of the press, freedom to assemble. But what we're concerned with in this case is that first part. And that said that Congress shall make no law concerning the establishment of religion. So Congress is never going to say the United States is a Christian country, or the United States, is a Catholic country, a Protestant country, Jewish country, Muslim country. That is outlawed under the First Amendment. So it's easy to say something like the United States could never declare an official state religion. But there are a lot of situations where it seems a little more complicated, where it's not totally clear is what the United States, is what not just the federal government, but the state governments too, is what they're doing equivalent to saying, well, we really have an official religion, or is it totally permissible? And one case where this comes up is legislative prayer. So as you might know, lots of legislative bodies in the United States have chaplains and have prayers that are given before a session. The United States Congress, for example, has a chaplain who will lead people in a prayer often before Congress meets. And a lot of state legislatures, a lot of town legislatures have the same thing. And over the years, various people have said, this seems a little funny that First Amendment says there's no establishment of religion, but here we are, we're using public funds to pay ministers, to lead congressmen in prayers. That feels a little like we do have an official religion. But the court generally has said, no, this is okay. In particular, there's a famous case called Marsh v. Chambers, where someone challenged legislative prayer, and the court said, this is really acceptable. It's acceptable because the prayers here aren't really sectarian. It's more general. We're accepting a lot of kind of general faith traditions and not clearly promoting or denigrating anyone's religion. And then also, this is just part of who we are. We've been doing legislative prayer since the beginning of our country, and we're religious people, and it's okay to have a reflection of that as long as the prayers aren't too kind of clearly sectarian. So that's been the law for a number of years now, but Town of Greece v. Galloway brings up a slightly new application of it. And Town of Greece v. Galloway is about not a state legislature or the national legislature, the Congress. It's about a local town board. And at their town board meetings, they would have various clergymen get up to give a prayer at the beginning. And a town board meeting is a little different than your average legislative session. So this wasn't just the minister leading people, elected officials in a prayer. He was leading the whole group, the whole audience. Lots of people come to town meetings in order to bring a petition or discuss a permit grant or anything like that. So the question is this like Marsh v. Chambers? Is this like all the situations of legislative prayer that the court has said are totally acceptable? Or is this somehow different?
So the town of Greece in this case is the petitioner. And that means they lost in the court below and are getting the Supreme Court to reconsider that decision. And one of the first arguments that they rely on is essentially saying this is just like Marsh v. Chambers. It's an argument about the historical tradition of towns across the United States, which, just like the federal legislature, have often had prayers that start meetings. And so the argument is sort of, if it's all right for the federal legislature, to do this in large part because of this long-standing American tradition, then it should be all right for towns to do this, and because of this long-standing American tradition as well. But that doesn't, get necessarily to everything that Daniel raised about the dissimilarity between Congress and town meetings, and town meetings maybe somewhat more involve the people of the town, somewhat more involve non-elected officials. And so there's then this worry also about those people getting a message about the government's endorsement of one religion or another, and whether that violates the Establishment Clause of the First Amendment. And the town responds, that there's not just the phrase of the First Amendment that says, Congress shall make no law respecting an establishment of religion. There's also the part that says Congress shall make no law prohibiting the free exercise thereof. And the town of Greece says that the part of the purpose of the First Amendment is to ensure the freedom of worship and conscience for people in the United States. And here, this prayer session is a way of doing that. And it also says there aren't really the same worries about an establishment of religion, because the town allows volunteers from all kinds of faith or non-faith persuasions to come and lead a solemnization at the beginning of each meeting. So, for instance, just in the last year, they've had members of the Jewish faith, Catholic faith, Mormon faith, Buddhist faith, Baha'i faith, Wiccan faith, and many more. And they've never rejected any request by someone. And they also don't look at the text that the person chooses to read beforehand to approve it. So they say, if the First Amendment, if you look at the purpose of the First Amendment, the framers were worried about establishing a national church, establishing the government saying this religion is the religion of the state. And they're saying, look at the way that this is practiced. This is practiced as a reflection of the diverse faiths of many Americans. We don't reject anyone, and we've taken all comers, and we let them say what they want to say. And it's resulted in diverse presentations. And so they say, if you look at really the First Amendment, you shouldn't think of this as questionable about the establishment of religion. It's not an establishment of religion, and it's allowing people, moreover, to express a variety and diversity of religious viewpoints.
So the respondents in this case, and that's Galloway, who is a person who attended some of these town meetings and didn't like the prayer, says, first off, that all this talk about including a variety of faith traditions, it's a little fishy, because for the vast majority of these prayer sessions, it was Christian ministers giving explicitly Christian prayers with very kind of sectarian language. And then at the end, once some of the complaints arose, once there was a threat of litigation, all of a sudden the town made an effort to bring in a Baha'i, to bring in Wiccan, to bring in Jewish. But it was clear, at least for most of the history of this practice, what was going on, and that was that the town was engaging in explicitly Christian prayers. An interesting thing, actually, if you're curious to hear some of the content of these prayers, is to go look at the transcript for the oral arguments in this case, in which Justice Kagan, who's one of the justices of the Supreme Court, did a really fascinating thing. And at the very beginning of the oral argument, when the town of Greece's lawyer was about to start, she cut him off and she said, suppose at the beginning of this court session, the Chief Justice had said, and then she recited one of these prayers, which has a lot of references to Jesus Christ, our Lord and Savior, and Christian doctrine. She said, would that have been okay? And that's a really tough question to answer, because it certainly sounds, when you're hearing this, like this isn't necessarily about bringing in every faith tradition. This is about saying we believe in a particular faith tradition, and that's what our town's endorsing. And then the second big point that the town of Greece, that the respondents here make, is that what the town of Greece is doing is really not like Marshy Chambers at all. It's not like typical legislative prayer, and that's because it has a coercive effect. That if members of a legislature don't like a prayer, don't want to participate, they don't have to. But when individual citizens are coming before a town board to petition it, to try to get it to do something they want, to participate in their government, when they're sitting next to their friends and neighbors, and a minister gets up and asks the whole town to participate in a prayer, they're going to feel really uncomfortable walking out or sitting down when everyone rises or refusing to bow their heads in prayer when everybody else does. And that kind of coercion is what the Establishment Clause is about protecting against, right? That the Establishment Clause is supposed to say government can't force people to adhere to any particular religion or to participate in any religious ceremony. And that's really what's going on in this setting in a way that's totally different from other legislative prayer contexts that the court has considered. So I hope you enjoyed hearing about some of the arguments in 3 of these Supreme Court cases. And as Danny mentioned earlier, none of the opinions from these cases have come down yet. So it's an open question what's actually going to happen. And it'll be really fascinating to see. But so we're excited to see what happens. And we hope you've enjoyed talking about these cases with us today. Thanks so much.
Have a good time. We'll see you at the next interactive session.